like to talk about just three aspects on the subject of recusal. And I'll be making reference to the materials and immediately related. But a recent Supreme Court decision delivered on 11th of October 2024. Your Lordship, on my right and on my left, our counsel were involved in this matter where the Supreme Court was asked to recuse itself, which means this is very limited, and 5 others versus East African Development Bank. This is a manager and the senior counsel comment on the same side, but today on different sides of that decision. When that application was made before the Supreme Court, I do not want to go through all what went on. I want to go straight to paragraph 27, where the court said, having arrived at the inescapable conclusion that we are being accused of bias and working towards an undisclosed predetermined outcome, we are strongly persuaded that our further participation in these proceedings will not serve the ends of justice, at least in the eyes and perception of the appellant stroke applicants. Consequently, and inevitably, each of us, his bench, does hereby recuse him or herself from further participation in the hearing and determination of the appeal dated 25th April 2023 and filed on 26th April 2023. That's a position that was made just for these petitions were concluded. So, when allegations of bias and working towards a certain outcome for the Supreme Court recently is recused itself. My Lord, I have a decision, an Indian decision. It's called the State of Punjab versus the Vita Pal C, which also the question of recusal was discussed at length. And again, I do not want to dwell. The whole decision is a very lengthy one, it's about 400 pages. But at page 9, paragraph 16, the court sets the standard that is applied in determining whether a bench should recuse itself. And the test, right? The test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and whether the adjudicator was likely to be disposed to decide the matter only in a particular way. And the court went on to say, the court has to proceed observing the minimum requirements of natural justice, i.e., the judge has to act fairly and without bias in good faith. A judgment which is the result of bias or want of impartiality is a nullity and a trial, quorum and judice. Therefore, the constitutional order in is liable to be enforced. Lastly, and this is what is very important, at paragraph 18, the court said in part, however, if there is real ground for doubt, that doubt must be resolved in favor of the accused. So that, my lords and my lady, if you are in doubt whether you should recuse yourself or you should not recuse yourself. That doubt should weigh towards recuse. That decision will be shared. And then the court went on to quash some proceedings which had taken place, the appeal had been determined, and then this one went all the way to the Supreme Court of India. So the court said that that is how situations of bias are treated. I had reference to the code of conduct of our judicial officers, because that's what is the level of the parliament. But my lord, I want to make a business as to where those provisions are obtained, and those provisions are obtained from the IDA guidelines on conflict of interest in international arbitration. You will find that material is published by the I wanted it from the International Bar Association, and it was done first in the year 2004, and it has been applied worldwide as a guide on determining situations of conflict of interest. And it has graded conflicts in several shades. The traffic light shades is green, is brown, and is the waivable, sorry, non-waivable, green, and the brown. And at clause 2.37, one of the situations that is a waivable conflict is the arbitrator has a close family relationship with one of the parties, or with a manager, director, or member of the supervisory board, or any person having a controlling influence in one of the parties, or an affiliate of one of the parties, or with counsel representing a party. Going with the materials, if they are true, that was stated by my other friends, then that situation has already arisen. And therefore, it is a good ground for imprisonment. But I don't want to take much more time. These materials will be circulated. There's much more in these materials that speak towards the case of the situation that is not. Thank you very much.
Sorry, counsel, does the court have the benefit of the authority that you have to talk to in that case and the ICA case?
Yes,
the ICA
The owner also wish to say something on behalf of the second petitioner in 565. If I'm allowed to proceed.
Who are you?
Can you see me?
Your name?
I'm virtual. I'm online.
What is your name? What is your name?
Timodo Teresia Wanjiro Makazi from Kilgoya.
Yes, proceed.
Yes, thank you. I just wished to support that application by just submitting that public perception is everything and it cannot be ignored. I wish to rely on Article 47(1) and Article 50, and more specifically in Article 47(1) is where it says that every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. And more specifically on the part that is procedurally fair. Yeah, if you look at the way the court has conducted itself, of course we are in no doubt that the court is competent enough to handle these petitions, but then again, on the issue of the procedure, we had raised an issue of service, and the court ruled that we should check all documents in the portal. Unfortunately, today, we could not access the e-filing portal. So what one is meant to wonder is why we were told to access documents online, and when we go to the portal today morning, it's not working. Therefore, there is this perception that perhaps there could be something going on, because at all material times, judges shall be impartial. And the issues being raised currently are that there is an issue. Sorry? Okay. So there are issues that are being raised that are raising issues to conflict of interest, whereby we have been directed by the applicants to note that one of the judge has a spouse who has been nominated or appointed by the President of Kenya, His Excellency William Ruto. And I think that is not a question where we should be giving out affidavits. I think that is a question where the judge, the honorable judge, should just come out and tell us if this is true. Then are we going to feel conflicted, so that we can, as petitioner, say, okay, proceed, or no, let's have a neutral bench. The other issue is the issue of another judge, Honorable Justice Murima, being seen. No, not the judge, I'm not saying the judge, I'm saying the spouse of the judge being nominated or appointed. That's the issue that has been raised by the applicants. And so we feel, of course, if this appointment was done, will he be able to Murima attending a wedding ceremony, Kindiki? So the issue is, and they are long-time friends, will he be able to disappoint a friend? You know, these are the issues that the public is asking, and it's the perception anyway. So in issues such as this, we say these issues are very important and they cannot be ignored. And there's no point of, if people are saying we don't want the bench, it's not so hard for the bench to say, okay, just let's go back to the Chief Justice, please appoint another bench. There's nothing wrong with that. We know the judges are competent enough, but then if the issue of conflict of interest is arising, then the best thing to do before we go to the substantive issues is to pen everything down and say that go back to the drawing board and appoint a new bench. That's all.
Thank you, Mr. Roshi. My name is Danstan Omari. I do appear for the third interested party, One Party Democratic Movement Party, together with Mr. Kala. My Lord, I want to say only one short thing, and then allow Mr. Kala to conclude, not repeating what has been said this afternoon. My Lord, in 2008, I was involved in a matter which started the Vice President of the country. I appeared before Justice Paul Kihara, and he immediately told me the second respondent is my personal friend, was my classmate in law school. I recused myself. I was sent to Justice Wendy. I appeared before her, and my Lord, she said, the first applicant, a renowned professor, is my personal friend, and I recused myself. My Lord, I ended up with an out-of-court settlement. I do ask Mr. Kala to conclude.
My Lord, my lady, I just make one submission, but in light of the disclosure about the relationship between Justice Murima and the Speaker of the Senate. We find ourselves in a very unfortunate situation where the bench looks like it's on trial. Motions of recusal are normally very difficult to prosecute, because the question is, and this is a question that respectfully I want to pose to the bench. Will you feel comfortable? Do you appreciate the fact that so far the events that have taken place, whatever determination that you will arrive in this particular matter, then there are weighty constitutional national matters that affect the entire country, are you satisfied that they will be received well by the public? That's a question that should be in the mind of the judges as they decide whether to recuse themselves or not. Secondly, it is very clear that the only mistake here was that Justice Murima did not disclose a relationship between himself and Amason King, which is out of a friendship and which is not even illegal. But disclosure, the mere fact that there was no disclosure by itself creates suspicion, apprehension in the minds of the applicant. The last question is, if Justice Murima decides to recuse himself, is it the entire bench that will recuse itself, or only one judge will recuse himself? Because I'm convinced that inevitably Justice Murima must recuse himself. Thank you so much.
Your Lordship and my lady, with the please you, my name is Akimpa. I do appear for the third petitioner in the consolidated petition. Your Lordship, mine is just to put into context the Supreme Court decision in Dari and 5 others versus East African Development Bank. So, Your Lordship, in that particular matter, I want to say that first of all, it was before the Supreme Court, and notwithstanding the doctrine of necessity, the Supreme Court considered that the right to a fair hearing by an impartial tribunal was so sacrosanct that the Supreme Court did not even consider the doctrine of necessity. So I just want to read paragraph 26 where the Supreme Court says, what is undeniable is the fact that by resorting to this course of action, the applicants are unequivocally accusing this bench of lack of impartiality, fairness, and integrity. Such an accusation against a judge goes to the very core of his oath of office. Coming from a party to ongoing proceedings, such an allegation must strongly persuade the judge to recuse themselves. So that is what the Supreme Court said. So, Your Lordship, in that particular paragraph, the Supreme Court is saying that if there is an allegation, especially because this instance is actually almost same to that, because there was a complaint that was lodged against that bench before the Judicial Service Commission. I have heard today that the first petitioner has already lodged a petition before the Judicial Service Commission. Your Lordship, I beg that you are guided by this decision in holding that the right to a fair and impartial tribunal is very clear.
Thank you, but I think you should let us know about the petition which has been done, because I don't think parties are aware of that.
Your Lordship, I think it is in the further
A petition?
No, not petition. We
What
had
is it?
A complaint that was
Don't mislead the public. There's a whole difference between a complaint and a petition. Don't mislead the public.
He's the one who has said petition.
All right.
Thank you.
Please, the court. My name is Dr. Eboso from Kindiki County, and I'm petitioner number 11 in the consolidated petition in the cohort 1. As I sat as a petitioner who essentially had no issue with the sitting of the bench, because when a petitioner files a petition, there is a presumption that the bench is properly constituted, and that Kenyans elected the Constitution of 2010, and in it provided the independence of the judiciary and the conduct the expected conduct of judges. And therefore, we as Kenyans have trust in the judiciary and the individual judges at the time when they are appointed and during the course of their performance of functions. But as I sat, I agonized over the issues that have been raised, and at the outset, I realized that the recusal application has been made to this bench to recuse itself, or some of the judges to recuse itself, but as a decision of the bench. And I agonized over whether recusal or the place of recusal proceedings in a setup like ours. And perhaps this was amplified by the back and forth that we saw with regard to the facts that were coming out. And I would wish to be persuaded by Dr. Kaminwa that really recusal proceedings and the kind of facts that come to light ought not really be a subject of litigation for several reasons. One, recusal proceedings are really against individual justices, and they relate to the personal conduct which really lies in the mind and conscience of the individual judge. I would give an example. Suppose we ask the bench for one of the judges to recuse themselves, and two of the justices disagreed with the recusal, but the very judge who we are asking to recuse themselves. Would we then say that this bench has ruled that the judge must sit? So it's really an individual decision of the judge to reflect upon the facts that are before him, the relationship that is being alleged, because why it can't be litigation, and it should be in the interest of all the parties that the judge is not biased, such that when you make it litigious, what happens is one side will be claiming the other side must prove a point, which they are not really very materially cognizant of. And it's really just the judge who knows the actual facts of the issue. And so it really is upon the judge individually to look at themselves and ask themselves whether the facts that are being alleged constitute what would amount to a bias. And when we make it litigious like this, we actually violate the Constitution for the reason that the conduct of a judge is not meant to be subject of any proceeding before court. That is a matter that should be before JSC, that should be before other tribunals. And the Supreme Court has told us that in Bellevue, that the conduct of a judge, because that's what is being alleged here, a judge is being alleged to have concealed information that they ought to have given. A judge is being alleged to have abused office by sitting on a particular day and whatnot. So those are things that really should not be a subject of a proceeding if we really intend to proceed with this matter. Suppose this bench does not recuse itself, then how does the matter proceed in that manner? I'd like to point out that I think I've already talked about the fact that the facts relating to a recusal, the person who really knows what those facts are and the extent to which they are is the judge. And so any discussion as to whether we proved the case or not proved the case is neither here nor there as relates to this issue. I'd like to refer the court. I don't know how we quote precedents, but I'd like to refer the court to a decision of the Supreme Court of the United States in Jewel Ridge Coal Corporation versus local number 6167, United Mine Workers of America in 1945. And there the court, the Supreme Court found that I think one of the parties was asking for the entire bench to recuse themselves. And I'll just take maybe one more minute for the entire bench to recuse themselves. And the Supreme Court of the United States found that that decision cannot be made by the bench. And a question of recusal should be directed at the judge, and it should be the judge to make the decision whether they themselves will recuse themselves or not. It was also, again, captured in 1980 in a decision called Hanrahan versus Hampton, still at the United States Supreme Court. And in India, in 2016, Advocates on Record Association and others versus Union of India. Justice Madan also pointed out the same, and finally, I'd like to refer the court to the fact that this is a sensitive matter, but it's also, as sensitive as it is also an urgent matter, as considered by the bench and as considered by everyone. That there is the aspect of necessity that this matter must be heard, and there's also room for appeal should any person feel they are aggrieved by decisions of this court or the judges herein. And so what I would say is that I would ask that the individual justices that you look into the issues that have been raised, you look into the facts which you are familiar with them yourselves, and go home and reflect whether indeed you will have the impartiality to hear this matter. And once you make that decision, let's hear the matter and proceed. Thank you.
My lords and my lady doctor, with the please with the matter, my name is Wamboi, Shadrach Wamboi. I speak with the blessings of my senior, Mr. Danstan Omari and Samson Aderi, on behalf of the 9th petitioner. My lord, at the very outset, permit me to submit that this court has a duty, either individually or as a collegial bench, to hear and determine the matters that are presented before court. Indeed, just like any other person, you have a duty to act in the defense of the Constitution. However, matters that relate to the calling to question of the conduct or the integrity of the bench or a judge are matters that are characterized in this country with a lot of rage, as we have even seen being demonstrated in this honorable court. In other occasions, applications for recusal, my lady and my lords, are said to be a dialogue of the deaf and a dance of the blind, to the extent that the petitioners or the applicants making an application such as the one that finds itself before you sometimes refrain from even saying the very grounds upon which they make the application, as you have seen before this court. And again, the bench on the other end, on many occasions, tends to draw conclusions of what they would think the applicant is saying about their conduct or their integrity. So for that reason, my lady and my lords, the court is then called upon to reflect as to its duty to do that which is just vis-a-vis the perception, either actual or apparent, that will flow or be submitted by applicants who call to question the conduct of the court. My lady and my lords, permit me to also make a contribution with regards to the decision that has been made in the Supreme Court case of Dari Limited. And there is something that is important that we must highlight. In this application, the court, the Supreme Court, was not called upon to adjudicate on an application for the recusal of the court. That was not the application that was lying before court. What is important that we must underscore in this case is that the court was invited to suspend or stay its proceedings in view of a complaint that had been made by the applicants before the Judicial Service Commission, so that the court ultimately ended up recusing itself, not that it had been invited to recuse itself, but because there had been a complaint that had been filed before the Judicial Service Commission. My lady and my lords, the reason why the 9th petitioner rises in support of the submissions made by counsels who have made the application is largely due to our duty as the officers of the court. And we have seen in the application in petition number E015 of 2024, annexure marked annexure marked DMM2, which is a letter addressed to my colleague, Mr. Swanya of Swanya and Company Advocates from the Judicial Service Commission, highlighting a complaint that has been made by the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua, against this honorable bench. So, my lady and my lords, as I rest, the question that begs the answer is simple. If a complaint has already been lodged against the persons of this honorable court, how will a reasonable person, or will a reasonable person out there be confident that this court, in light of the complaint that has been lodged against you by one of the petitioners, arrive at a just finding in this case? My lady and my lords, that should mark the end of my submissions. I shall pave the floor for the remaining minutes to my seniors to also speak some wisdom to what is in issue. Thank you.
My lady and my lords, my name is Samuel Berry, for the 9th question of the second court. I stand in support of the motion for recusal, and I juxtapose it in this manner. Recusal applications are tantamount to the court being on trial. It's a charge sheet for the court that it then will determine the parameters that have been set and the grounds that have been accused to find or make a finding whether they merit. And in so doing, the court will not be given an opportunity to make submissions as we are doing. It's the court that is going to now render a ruling. Then the big question that we ought to ask ourselves, whether then the court is going to rebut on the heavy submissions that have been made, because going into the second room of going to analyze what the petition is all about will mean that we as the petitioners will have faith in even opening the second chapter of the proceedings as they are going to happen. So therefore, my lord, my lady, the point we are making is, kindly, there is enough evidence that has been laid before you to make a determination that indeed it is not available for the court to open the second chapter of going into the determination of the petition. I rest my case there. The balance of my time, I invite Omari to finish up our comment.
My lord and lady, I'm very, very brief. One, the court, in determining whether the DCJ has powers to constitute a bench, made a finding that the petitioner was found guilty of an offense of addressing the gathering. His lawyers, all of them, never addressed the court. The lawyers were not addressing. It is the petitioner who was addressing. You have already made a decision that the petitioner was addressing the gathering. We really have confidence to appear before him. Amin Nasir Senior, when he was constantly spotted by the Supreme Court that he was attacking the court decided to punish. When he appeared, all the members of the Supreme Court recused themselves. They never gave him audience. Will the Deputy President have audience before you when the main substantive motion comes before you? You have already made up your mind that his job is to address the public. The rationale for this matter, going live and my brothers and sisters saying it's a public interest matter, is because 55 million Kenyans are waiting to see the free learned judges appear in passion. It is our submission from our plant Sheria Mtaani that based on that, you recuse yourself. I'll give a small analogy. When I went to pay dowry for a friend of mine, we were told that that place, those people were witches. So that religion, when food is being prayed for, you must close your eyes. We never closed our eyes because behind us we feared, my Lord and my lady, that these guys might destroy us. The petitioner is scared of the stage. That's right.